It's very exciting to be here at this first ever National Summit on Collateral Consequences. This is a topic on which the ABA has been a leader for years, and this meeting is an additional way in which we are demonstrating our dedication to this critical issue. Again, I'd like to thank Cynthia and Jim not only for the warm introduction, but also for all of the hard and important work they perform as chairs of the ABA Criminal Justice Section. This summit is historic and culminates 5 years of effort by the ABA Criminal Justice Section with the support of the National Institute of Justice to produce a national inventory of the collateral consequences of criminal convictions throughout the entire United States. Let me remind you how the ABA got involved with this project. Under the leadership of Senator Patrick Leahy, Congress provided funding for the National Institute of Justice to award a grant to conduct what is now available as the National Inventory. The NIJ awarded a $750,000 grant to the Criminal Justice Section of the American Bar Association. Since then, the Criminal Justice Section has spent almost $1 million of its own funds to develop the inventory and to make it as complete, accurate, and accessible as possible. In the end, the inventory compiled more than 45,000 different consequences of conviction on the books of the various states and the United States. This enormous undertaking could create a sea change in the way legislatures, judges, lawyers, and the public think about the kinds of dispositions of criminal cases that promote public safety. At the same time, it can improve the chances of offenders to become contributing public members once they complete their sentences. Why was the Criminal Justice Section willing to spend the money and do the Herculean work required to make the National Inventory a reality? Some numbers may help to explain. In the early 1970s, many states and the federal government sought to attack rising crime rates by getting, quote, tough on crime. Prosecutions and the length of jail and prison sentences increased. Listen carefully to these numbers, please. In 1974, 1.3% of the adult population, or 1.8 million people, had served time in prison. That's in 1974. The percentage increased to 2.7%, or 5.6 million people, by 2001. In 2013, the number of adults under correctional supervision, that is, adults who are on probation in jail or prison and on parole, was 6.9 million people, a staggering number. That includes almost 4.8 million people on probation or parole, or in other words, living in our communities, 4.8 million people. While the correctional supervision rate has trended down some in the past 6 years, it has grown 275% since 1980. So what do all these numbers have to do with the National Inventory and collateral consequences? Everything. Everything. Supreme Court Justice Anthony Kennedy explained why when he gave the keynote address at the annual meeting of the American Bar Association in San Francisco on August 9th, 2003. He reminded American lawyers and the American people that 95% of those who are incarcerated will be released, and made the point that if they return to their communities unable to find jobs and housing, they have little chance of turning their lives around. They were likely to find themselves back in jail or prison. He did not have to make the obvious point that those placed on probation also need jobs, housing, and access to education. The ABA responded to Justice Kennedy's speech by creating the ABA Justice Kennedy Commission, chaired by King Steve Salzberg, and he did a remarkable job. A year to the day after Justice Kennedy spoke, the ABA House of Delegates approved 4 resolutions from the Kennedy Commission. That was followed by the ABA Commission on Effective Criminal Sanctions, which produced 6 resolutions approved by the House of Delegates in 2007. These resolutions addressed many aspects of American criminal justice. One in particular was recognition of the huge impact that harsh sentencing practices had on minority communities. Approximately 2/3 of those serving time were African American or Hispanic. In some cities or neighborhoods, the percentage of young males of color who were convicted felons approached 50%. In these places, an entire generation of young people was at risk. Both the Kennedy Commission, is that Steve calling me? Did I say something wrong? I don't know what that is. Shall we keep going? Both the Kennedy Commission and the Commission on Effective Criminal Sanctions noted the rate of recidivism among those convicted. The criminal justice system was convicting and incarcerating more and more people, and these people too often committed additional crimes upon release. There was a cycle of crime in which millions of people were caught and communities were devastated. The ABA House of Delegates resolutions recognized that the revolving door of conviction, incarceration, release, rearrest, reconviction, and reincarceration was not reducing recidivism, and that only by reducing recidivism could we reduce crime and the number of crime victims. This philosophy has come to be known as smart on crime. Justice Kennedy pointed out that when someone has been judged guilty and the appellate and collateral review process has ended, the legal profession seems to lose all interest. He challenged us by saying this: as a profession and as a people, we should know what happens after the prisoner is taken away. We accepted this responsibility and sought to recognize not only that ex-offenders are part of the family, humankind, but also that they are part of their communities and often have families that love them and want them to succeed. Throughout the country, we saw how drug treatment programs, drug courts, veterans courts, and similar innovations can work to deal with problems like addiction that are associated with criminal behavior and to decrease the probability of recidivism. Throughout the country, we saw savvy prosecutors supporting reentry programs in the belief that they hold out a greater promise of reducing crime and making their communities safer than by repeatedly sending individuals to jail and prison. We saw judges adopting creative alternatives to jail and prison. But we also saw how one obstacle threatens to stifle innovation and frustrate efforts to assure that former offenders have a real chance to become successful members of their community. That obstacle is why we're here today. That obstacle is the collateral consequences that attach to many convictions. Maurice Alexander was a 61-year-old resident of the District of Columbia. He was caught up in a police roundup of young males and forced to lie face down on the sidewalk. As Mr. Alexander described it, and these are his words, "I became perturbed and I shook my finger at the police and said something to the effect of, 'Shame on you.' A jury found Alexander guilty of attempted threat to do bodily harm, a misdemeanor under the laws of the District of Columbia. He served 10 days in jail, and the conviction is on his record permanently." So what does that mean? 6 years later, it would cost him a chance at affordable housing and leave him homeless for nearly 7 months. The collateral consequences laws mean he can be evicted from low-income housing and barred from a myriad of jobs ranging from barber to security officer. Let us be clear about what collateral consequences are. When an individual is convicted, a judge, or in some states a jury, determines whether to impose a sentence of incarceration. At sentencing, a determination also is made whether to impose a fine or a restitution obligation upon a defendant. These are the direct consequences of a conviction, and they have limits. Once an individual has served whatever jail or prison sentence is imposed, completed any probationary, parole, or supervised release term, and paid any monetary obligations, the punishment period ends. This is not so with collateral consequences. These are disqualifications or disadvantages imposed by statute or regulation that prevent former offenders from obtaining public benefits, holding certain jobs, pursuing certain professions, obtaining educational benefits, or living in public housing. The shocking thing is that in many places, these consequences are never ending. A person who is convicted and placed on probation for 30 days may be burdened by collateral consequences for 30 years or even for life. Most people in America believe in the expression, paying your dues. Well, Maurice Alexander and millions of others in America have been paying their dues and a whole lot more than their dues. The general belief is that when sentences are served, people have, in fact, paid their dues. But because of collateral consequences, a conviction continues to exact dues every single day. In my home state of South Carolina, almost 700 collateral consequences are on the books. Unfortunately, that number is lower than in many states. They range from being ineligible to vote, hold a commercial driver's license, or obtain food stamps, to being barred from obtaining a barber's license. Certainly, there are good grounds why a criminal conviction should be a factor in deciding whether or not a former offender should be able to hold certain jobs. No one would require a daycare center to hire an individual convicted of child molestation. But most people would expect that if we offer educational opportunities to someone in jail or prison so that he or she would have the qualifications to perform a job upon release, we would not by statute or regulation disqualify that person from the very job he or she was trained to do while incarcerated. The truth is that in most jurisdictions, collateral consequences may be imposed automatically upon conviction. Often there is no mechanism by which to obtain relief from them. The result is that these collateral consequences become a life sentence harsher than whatever sentence a court actually imposed upon the conviction. Many states bar ex-offenders from public employment, and since many private firms decide not to hire ex-offenders, they are left with few, if any, options. No wonder that approximately 60% of formerly incarcerated individuals remain unemployed 1 year after release. Federal law includes a mandatory ban on access to public housing for people with certain types of convictions and grants discretion to local housing authorities to deny housing based on criminal activity. Entire households may be evicted. Entire households may be evicted based on the arrest or pending criminal charge of one member. This one-strike provision has a profound impact on family structure. Many families residing in public housing have to sign agreements that ex-offender family members cannot live with or even visit them at their public housing unit. It is no wonder, then, that nearly 1/3 of individuals released from incarceration expect to go to and end up in homeless shelters. Did Maurice Alexander's crime deserve a sentence of homelessness? In a majority of states, persons with felony drug convictions face a lifetime ban on receiving public assistance. In 2013, approximately 180,000 women were subject to the ban on such assistance in the 12 states with the most punitive policies. A study of persons recently released from incarceration in Texas, California, and Connecticut likened their level of food insecurity to that in developing countries. This barrier to accessing critical public assistance not only contributes to hunger and malnutrition, but also restricts access to mental health and substance abuse treatment programs. It just doesn't make any sense. For those offenders fortunate enough to seek higher education, the barriers do not end. Many former offenders are ineligible for student loans. The national inventory brings transparency to what was a complex and largely hidden part of criminal justice. Now, for the first time, there's reason to believe that conscientious judges and lawyers will pay attention to the collateral consequences as they dispose of criminal cases. Before defendants plead guilty to an offense, they can see the full effect of what that plea may cost them. While many people in trouble with the law are most interested in the immediate concern of staying out of jail or prison, a concern we all can appreciate, the long-lasting consequences now can also be evaluated by lawyers and judges in determining punishment, and the defendant will at least know up front what is at stake. There's reason to hope that conscientious legislators and agency officials will examine the collateral consequences and eliminate or modify those that unnecessarily stand in the way of an individual being able to reclaim his or her place as a lawful, contributing member of a community. This is important to the ABA because it is a matter of justice. It is important to America because it is a matter of fairness. And it is important to every person in this room and in the United States because it is a matter of morality. As the ABA Kennedy Commission so succinctly stated, and I quote, "Once society has exacted its price from an individual, there is a strong case to be made that society should not only permit, but should encourage that person to make a positive contribution to society." I look forward to joining you in this important summit. I thank you for your hard work and attention, and I hope we can continue to pursue the causes of justice and fairness.